Well, good evening, everyone, and welcome back to AJ 101 Criminal Law Online. My name is Tony Farrar, and I am your instructor for this semester. Now, tonight's lecture is going to be on Chapter 6, where we are going to talk about defenses, more specifically, excuses and insanity. Now, if you recall back in Chapter 5, we talked about justifications as defenses, and we talked about the different types of defenses and what they call an affirmative defense, and also justification as a defense. Well, Chapter 6 is going to look at a little bit deeper into the nature of excuses and the different types or forms of excuses. We'll explore a little bit on mental incapacity, and we'll look at what is insanity. So that's kind of where we're going to go for Chapter 6. So with that being said, let's go ahead and jump right into our lecture for this evening. Now, in July of 2010, a woman by the name of Sakwa Akhtar, a 34-year-old mother, called 911, and her first words to the dispatcher was, "I killed both of my kids." The 911 operator, who initially disbelieved what she heard, eventually ascertained that this woman unsuccessfully attempted to kill her children that were ages 2 and 5 by having them ingest bathroom cleaner. But she said that they wouldn't drink it, so she then strangled them with an audio cord. And when they asked why she killed them, she replied something similar to, "They are both not normal, they're autistic. Both are autistic. I don't want my children to be like that. I want normal kids." Now, during the conversation, the 911 operator overheard Akhtar washing bathroom cleaner from her hands. And in response to the 911 operator's question about what she was feeling, Akhtar replied nothing. The police, who were subsequently dispatched to her house, found the two children unconscious, one with the cord wrapped around his neck. One child died that night and the other the next day. Authorities discovered evidence that this woman had been planning the murders for weeks. Now, Akhtar pled not guilty by reason of insanity at the time of the murders, and experts testified at a hearing on the insanity defense that Akhtar was schizophrenic and that she thought she was saving her children. In 2014, the trial judge in the case found her not guilty because of her insanity at the time of the crime and ordered her confined to a mental treatment center. The judge commented that the case was tragic and that there was really no good solution. The crime of filicide, and I'll define that a little further in a moment, the murder of a child by a parent, is so shocking and apparently inconsistent with human nature that it challenges the imagination, really, to think that it's not caused by insanity, because who would really do that? At least that's some thinking of some individuals. So the chapter that we're going to go through tonight, Chapter 6, takes a look at insanity and some other legally acknowledged excuses, not some of those crazy things that are out there. And there are all kinds of different defenses that are brought up, but we're going to look at some legally acknowledged excuses to criminal conduct. So I have a link here, excuse me, to the a little video about this particular incident if you want to watch it. We won't watch it now, but I have it there available should you want to see a little bit more information. Now, again, as we discussed in Chapter 5, justification declares the allegedly criminal act legal. Now, excuse admits the criminality, but declares the allegedly criminal actor, the suspect in the case, if you will, not to be worthy of blame. And sometimes it's hard for us to kind of wrap our hands around this whole thing. An excuse admits that the action committed by the defendant was wrong and that it violated criminal law, so they're admitting that there was a violation of law, but again claims that the defendant should be excused from criminal liability by virtue of a special condition or circumstances that suggest that the person was not responsible for his or her deeds. So again, by definition, an excuse admits that the action committed by the defendant was wrong, it violated criminal law, but it should be excused by virtue of those conditions or circumstances that suggest that the person was not responsible. Now, the majority of excuses are personal in nature. They claim that the defendant acted on the basis of some disability or some abnormal condition like intoxication or insanity or even immaturity. And the disability alone is not sufficient to excuse him or her of the criminal responsibility. So we have to kind of, understand that. Only when the disability has the effect of in some way contributing to the criminal activity in question will the person be excused. And it doesn't mean that they're going to get off, scot-free sometimes. So like justifications, excuses are affirmative defenses, and they have to be raised by the defendant. So we have to remember that, okay? So, again, these are like justifications, and they're what we call affirmative defenses. If you remember the definition of an affirmative defense, take a second and think about that and tell me if you can remember what it is. Well, really quickly, so we don't waste a lot of time, this is an answer to a criminal charge in which a defendant takes the offensive and responds to the allegations with his or her own assertions based on legal principles. And affirmative defenses, again, they have to be raised and supported by the defense, independently of any claims made by the prosecutor. Okay, so that's the kind of going back and reviewing the definition. So let's take a look now at forms of excuses. There are several forms, if you will, of excuses that are recognized by law, and we're not going to go through the crazy ones that might be out there. Maybe we'll have time to talk about the Twinkie defense, or I'll throw a video up there, but let's look at some recognized forms. So the forms listed here are duress, and we'll go through each one of these independently. Involuntary intoxication, mistake, age, what we call entrapment, and then that big word insanity, and then something that they call diminished responsibility, which used to be diminished capacity. So let's start with duress. Now the model penal code says, and I'll quote this, it is an affirmative defense that the actor engaged in the conduct charged to constitute an offense because he was coerced to do so by the use of, threat to use, unlawful force against his person or the person of another, which is the person of reasonable firmness in his situation, would have been able to resist. Now, I know that's kind of some legalese, but let's look at duress. Okay, this kind of leads us into the formula of duress. The defense of duress, sometimes called compulsion, excuses a person from criminal liability because as a community, we conclude that it is reasonable for the person who committed the crime to have to succumb to the threat or coercion that was the cause of the criminal act. Now, hence, okay, so the mother forced to rob a bank by someone holding her children hostage, the captured military officer, as an example, compelled to provide secrets to an enemy under threat of torture, and the pilot of an airplane who flies off course after his or her plane has been commandeered by terrorists are all forced to commit acts they would not perform otherwise. So we can kind of go back to that sentence that we looked at that says, as a community, as a citizenship, if you will, we can kind of understand, we can conclude that it's reasonable for someone who commits a crime to have succumbed to the threat of coercion that caused that subsequent criminal act. So hopefully that kind of spells it out a little bit. Now, kind of an interesting case, back in 1997, 53-year-old Jose Fernandez Pupo was his name, a 30-year veteran of Cuban's military intelligence and police services, was acquitted by a federal judge in Tampa, Florida, on charges stemming from the hijacking of a small Cuban plane flowing to the U.S. controlled territory. Now, he admitted that he commandeered a Cuba taxi flight over the eastern part of Cuba and forced it to divert to the U.S. Naval base station at Guantanamo Bay. And he also admitted having been armed with 2 firearms at the time of the hijacking, and did not contest the allegation that he fired one of the weapons out of an open cockpit window that showed that he really meant business. Now, he was arrested on federal charges of piracy, and he offered duress as a defense, saying that he had no alternative to breaking the law because the Cuban authorities, aware that he was headed, he headed up an underground anti-Castro movement, were about to arrest him. And a colleague, he said, had told him that a warrant had been issued for his arrest. And torture and death, he claimed, would follow. Now, at trial, the U.S. District Judge, Judge Green, informed the jury that Pupo could not basically be held criminally responsible for his act if the jury members agreed that he carried this crime out under duress. And she said the hijacking could be excused if the defense could prove that Pupo acted under what we call reasonable belief that he would have suffered immediate injury or death if he did not commit that particular crime. And the jury concluded that the defense actually met that standard. So a very interesting case. So in most jurisdictions, effective use of the duress defense must be based on a showing that the defendant feared for his or her life, or was in danger of great bodily harm, or that the defendant was acting to prevent the death of bodily harm to another. Now, the threat under which the defendant acted must have been immediate, clear, and inescapable. So, it's not like they can just throw out this defense and everybody's going to buy it. There are some factors that play into this. So again, the threat under which the person acted must have been immediate, clear, and inescapable, and must not have arisen from some illegal or immoral activity of the defendant. So there are some things that kind of play into this. So let's keep looking. Now the model penal code provides that the defense of duress is unavailable, meaning they can't use it, if the actor, the suspect, recklessly placed himself in a situation in which it was probable that he or she would be subject to duress. It's also sometimes called the at-fault exception. So that's something good to know. So for example, one who joins a street gang cannot later claim that the gang forced him to engage in illegal acts against his will, because he joined the gang in the first place, and part of joining a gang is that you do criminal activity in support of the gang. Now, similarly, a prostitute ordered to shoplift by her pimp under threat of being denied drugs to support her habit would be hard-pressed to claim duress as a defense to a larceny charge. So, generally speaking, duress is a defense only when the harm caused by the crime committed is less serious than the harm avoided. So, finally, just to kind of finish up, the California Penal Code also limits the applicability of duress defenses to non-capital crimes in which the actor's life was threatened. And it reads as follows. I'll read it to you because it is significant. All persons are capable of committing crimes except, there's a little bit more, persons, unless the crime be punishable by death, so there's the capital punishment part, who committed the act or made the omission charged under threats of menace sufficient to show that they had reasonable cause to and did believe their lives would be endangered if they refused. So basically, it's kind of the same as some of the other sections, but it says, unless the crime be punishable with death. So there's a limitation in the California Penal Code. So hopefully that kind of clears up some factors surrounding duress. So let's move on to the next one, intoxication. So being under the influence of intoxicants can, in limited circumstances, be a defense. A claim of intoxication is generally not regarded as an effective defense, even when the intoxication results from alcoholism. And laws that codify, however you want to say it, the defense usually set strict limitations on the use of intoxication as a defense. Intoxication is not a useful defense because most intoxicated individuals are responsible for their impaired state, and the law generally holds that those who voluntarily put themselves in a condition in which they have little or no control over their actions must be held to have intended whatever the consequences were, or whatever those consequences are that might ensue. Now, that doesn't mean that somebody intoxicated can't become a victim of a crime. So I want to make that clear. But this voluntary intoxication type thing, sometimes it's not always a great defense. Again, because if you voluntarily put yourself in a condition in which they have little or no control over your actions, the court sometimes will look at, hey, well, you knew that could be a consequence of this voluntary intoxication. So you could still be a victim, but you may not be able to successfully use that voluntary intoxication as a defense. So hopefully that kind of makes a little sense to you. Now, in some jurisdictions, and for certain crimes, however, voluntary intoxication, it might lessen, criminal liability. So, such is the case where a high level of intoxication makes it impossible for a person to form, let's say, mens rea. Remember, the guilty mind necessary for a given offense. So, for example, because first-degree murder requires what, if you remember? Premeditation. A defense showing that a defendant was highly intoxicated while committing homicide and therefore unable to think clearly may result in a second-degree murder or even perhaps a manslaughter conviction. So it can diminish, if you will, or lessen, I guess diminish may not be the right word, but lessen, excuse me, a possible charge. So the essence of any defense based on intoxication can be found in the effect that an intoxicating substance has on a defendant's mens rea. Okay? Of course, intoxication may make it impossible to commit a crime. A man charged with rape, for example, could conceivably use expert testimony to support his contention that let's say it was impossible for him to achieve an erection because of his super intoxicated condition at the time of the offense. Now, such a claim, however, does not reference the mens rea of the defendant, but relies instead on the assertion that the crime in question did not actually occur because the defendant was too intoxicated to commit it. So, that's an interesting example, but it shows you there's a couple of different variations of how this intoxication defense can be used. So again, intoxication may make it impossible, if you will, or questionable for someone to be able to commit a crime. Now, there are two critical differences between voluntary intoxication, which we talked a little bit about already, and involuntary intoxication. So in your textbook, there's a capstone case law in there. It's Montana versus Eaglehoff. And this case provides a really interesting perspective on mens rea and voluntary intoxication. Now, like the law in many states, Montana does not permit voluntary intoxication to be used as a defense in criminal proceedings. The restriction was challenged, however, in an appeal that reached the U.S. Supreme Court, which is what court? Yes, you said it, it's the highest court of the land, on the basis that a defendant might be so intoxicated as to be unable to form the mens rea, the mind, remember, needed for a specific crime. Now, attorneys for the defendant argued that the right of due process requires that defendants be given the opportunity to present all relevant evidence to rebut or dispute the state's evidence on all elements of the offense charged. So with that being said, I'd like you to take a minute perhaps and read that case, because it is an interesting perspective on how mens rea works with voluntary intoxication. And it also is an interesting case on the fact of due process, where individuals do have the right to prevent all relevant evidence to rebut a possible charge or an offense charged. So keep that in mind as well. So voluntary intoxication, getting back to these two different definitions, this is where this is voluntary ingestion. Okay, injection or taking by any other means any intoxicating liquor, drug, or other substance. Now, involuntary intoxication, in contrast, generally results from the unknowing ingestion of an intoxicating substance, okay? And I kind of underlined unknowing. So this may result from having your drink spiked, if you will, or drug-laced food, or from following medical advice, and from situations in which an individual is tricked or forced into consuming some type of intoxicating substance. So you can definitely go back, and when you look at the bold, the statement here, there is a very critical difference between voluntary and involuntary. And if you can kind of think of it, remember, we talked a little bit, or actually quite a bit, about the mind, right? About intent and that mens rea, right? Well, voluntary intoxication, okay, we know that it's tough to use as a defense. You can still use it, and it might be able to mitigate some circumstances, but you did that on your own, okay? Now, if somebody does something to you unknowingly, if someone spikes your drink, do you think they had an intent to do that? And do you think their intent may be to commit some other crime? Perhaps they're not just going to spike your drink and walk away. Perhaps they're going to spike your drink and rob you. So think of that as it relates to the intent. And that's another reason why there is a very significant difference between the two of these. And some of the substances, just really, really quick, that are kind of out there would be like different date rape drugs and things like that. But three of the big ones are what that are out there are rohypnol, ketamine, and MDMA. And if you've never seen what they look like, they kind of look like this. I have a link to a video that if you want to look at the effects of MDMA and things like that, you can. But you can definitely look at the difference on how some of these things, and a lot of times they dissolve. Some of these dissolve in a drink, and you can't really see that they're there. And again, these are very powerful sedatives and hallucinogens, and a lot of the side effects are difficult to really understand. So, involuntary intoxication, again, is difficult to demonstrate in the case of alcohol, because the taste and effects of alcohol are both widely known in our culture, and it can be assumed that most people who consume the substance are aware of its effects. Involuntary intoxication, however, may also result from, like I said, the use of prescription or over-the-counter drugs containing substances in which the user is unfamiliar. So we know that involuntary intoxication generally results from the unknowing ingestion of intoxicating substances, and involuntary intoxication may serve as a defense if it either creates in the defendant an incapacity to appreciate the criminality of his conduct or her conduct, or creates an incapacity to conform his or her behavior to the requirements of law. And one case, for example, involved a hunter who assaulted other members of his hunting party. And in this case, expert witnesses testified that at the time of the assaults, the man was suffering from what we call toxic psychosis brought on by the excessive use of cough drops containing a chemical that is difficult for me to pronounce, but just take my word for it. He had consumed basically 12 boxes of these cough drops in the 24 hours preceding the attack, and the defendant was actually acquitted at trial. So again, kind of an interesting thing. Now, finally, intoxication or involuntary intoxication can also result from rare biological condition under which a person's body ferments food. Now, the internal fermentation process, which takes place in your intestines, and this isn't the health class, but this is actually true of involuntary intoxication, is caused by yeast, if you will, and in some can, in very few, but it could result in something similar to drunkenness, even though the afflicted individual has not really consumed any alcohol. So kind of an interesting concept. Involuntary intoxication may serve as a defense, again, if either creates in the defendant an incapacity to appreciate the criminality of his or her conduct, or creates incapacity to conform his or her behavior to the requirements of law. So that's number two. So what's the next one? So mistake. Can you actually just make a mistake? Well, let's take a look. An honest mistake of fact will generally preclude criminal liability in instances in which the actions undertaken would have been lawful had the situation been as the person acting reasonably believed them to be. An honest mistake is one that is genuine and sincere and is not a pretext planned, if you will, situation offered merely to hide somebody's intent. So, a 16-year-old Japanese exchange student, okay, Yasuhiro Hitori, was shot to death in Baton Rouge by homeowner Rodney Pierres when he went to the wrong house looking for a Halloween party. Now, Hattori, whose command of the English language was very poor, continued to approach Pierre's home when ordered to stop by the armed homeowner. And in this case, Pierre's was acquitted of manslaughter charges after claiming that he mistakenly thought the student was an intruder. Now, you're probably thinking, wow, can that really happen? Well, mistake of fact is a misinterpretation, okay, a misunderstanding or forgetfulness of a fact relating to a situation at hand. Belief in the existence of a thing or condition that does not exist. So, let's go a little further. An honest mistake of fact, again, will generally preclude criminal liability in instances in which the actions undertaken would have been lawful had the situation been as the person acting reasonably believed it to be. And a reasonable mistake is one that might be made by a typically competent person acting under the same set of circumstances. And I have here the example of the Hattori case, which is one that I just kind of outlined to you. So a man who forces a woman whom he does not know to accompany him on a journey she does not want to take, for example, would be guilty of kidnapping even though he believed she acquiesced to his request to accompany him. Now, in just such a case, the Indiana Supreme Court found a defendant guilty of kidnapping a woman who offered no physical resistance out of fear of the defendant, although she expressed verbal reservations. And any reasonable man under the same set of circumstances, said the court, would have realized that she did not want to go with him. In other words, the court basically said it like this: the appellant's assertion that he did not force the victim out of the laundromat provides some evidence that he honestly so believed. It is, however, no evidence of reasonableness of that belief. Apart from his statement, we find nothing in the record that suggests that a reasonable man in the appellant's position would have interpreted the victim's actions as indicative of her free consent to accompany the defendant. So again, there are times where there could be mistakes. Okay, and when we're a little bit further with mistakes as to fact should be distinguished from what we call ignorance of fact. And ignorance of fact refers to the lack of knowledge of some fact relating to the matter at hand, whereas the mistake of fact refers to a misinterpretation or misunderstanding, if you will, of the facts at hand. Now, both can be defenses to a criminal charge. As a defense, both ignorance of fact and mistake of fact may negate the mens rea, there's that mind thing again, for a specific offense. As one court said, the criminal intention being the essence of the crime, if the intent is dependent on the knowledge of particular facts, a want of such knowledge, not the result of carelessness or negligence, relieves the act of criminality. Now, again, and sometimes it's hard to kind of stay with this. Both ignorance of fact and mistake of fact may negate the mens rea required for a specific offense, and some mistakes do not relieve a defendant of criminal liability. When a person intends to commit one crime but actually commits another, that mistake of fact, if you will, is not going to be a defense. So you can kind of see how that plays out. So for example, if a burglar who breaks into the wrong house seeking money, he has heard is hidden, let's say, in a closet, will still be guilty of the crime of burglary, even though he may have broke into the wrong house and even though he was unable to locate the cash. So that mistake of fact is a little bit different. So hopefully that kind of clears it up. So a couple other definitions that we need to know before we move on to the next one. Another form of mistake, if you will, is mistake of law. And generally speaking, however, the courts have held that neither ignorance of the law, where one doesn't know that a law exists, nor misunderstanding of the law provides for an acceptable defense. And criminal proceedings assume that everyone capable of acting for himself knows the law. Now, this assumption does not mean, of course, that everyone is actually familiar with and knows every law, but it effectively compels people to learn the standards set by the law in their sphere of activity, if you will. So let's look at these two definitions. Mistake of law, a misunderstanding or misinterpretation of the law relevant to the situation at hand. Ignorance of the law, a lack of knowledge of the law or the existence of law relevant to the situation at hand. Now, again, these may be defenses in cases in which a given offense requires specific intent, and it may negate that mens rea. But as I said a minute ago, ignorance of the law, it may be an excuse where the law is not adequately published or is incapable of being known. So mistake of law may be a valid defense to a criminal charge if made in good faith under circumstances involving a bona fide attempt to ascertain the meaning of the law through reliance on a public official who is in a position to interpret the statute through the use of appropriate legal counsel. So that's mistake. And, kind of an interesting thing, but it does show us that there are instances in which we can make mistakes and they are applicable excuses. So what about age now? How does that play into everything? Well, defenses based on age, also called infancy defenses or immaturity defenses, make the claim that certain individuals should not be held criminally liable for their activities by virtue of their youth. So, I mean, think about it. Should a 12-year-old adult stand trial for murder? Do they really know the difference between, right and wrong? And is there a difference between the development of child's brains versus the already developed adult brain? And we'll talk about a couple of those things in just a moment. Now, the defense of infancy has its origin in very early Christian teachings, which held that children under the age of 7 were incapable of rational thought and planned action. Now, under common law, children below the age of 7 were presumed to be without criminal capacity, that is, incapable of forming the mens rea needed for criminal activity. Now, today, that rule still holds, and in most states, children below the age of 7 cannot be charged even with juvenile offenses, no matter how serious the action. Now, another rationale for the defense of infancy questions the assertion that children are too young to form the mens rea for the criminal act. And again, it's based on the belief that children, although they may act willfully, are too young to know better. They don't understand the consequences. As one writer says, the reason society holds minors free from criminal liability is not because they are too young to form criminal intent, but because they are presumed to be too young to make a conscious moral choice between doing good and doing evil. And in most states, again, children below the age of 7 cannot be charged with, juvenile offenses, no matter how serious they are. But most jurisdictions today do not impose full criminal culpability on children under the age of 18, but a number of states set the age of responsibility at 16 and some are at 17. So just kind of a little bit of information on that different states have different age limits as far as culpability and responsibility. Now, children under the age of criminal responsibility are in fact subject to juvenile court jurisdiction rather than the jurisdiction of adult criminal courts, although almost all states allow older children to be transferred to criminal court jurisdiction if the crimes they are charged with are especially serious or if the children are habitually in trouble with the law. And children who violate the criminal laws are officially known or referred to as juvenile offenders rather than criminals, to avoid the sort of stigmatism, if you will, that might follow them throughout their lives. And some of you are probably saying, well, shouldn't a criminal just be a criminal? Well, in the juvenile courts, it's a little bit different. So juvenile offenders may be adjudicated delinquent. They are not found guilty. The objective of the juvenile justice system is to rehabilitate delinquent juveniles, while the criminal justice system has multiple objectives, including rehabilitation, deterrence, retribution, restitution, and incapacitation. So, again, there's a little bit of different focus between the two. So transfer to an adult court requires a showing by the prosecution that a child was first able to appreciate the wrongfulness of his or her conduct and that the child had a guilty knowledge of wrongdoing. Also, that the child was competent to know the nature and consequences of his or her conduct and to know that it was in fact wrong. Now, finally, the defense of infancy is based on the chronological age of the defendant, and it has not been successful when based on the claims of mental immaturity. Now, I have a case that I'd like you to look at, and I'm not going to give a lot of information on it. I have the link here. You don't have to watch the whole thing, but there's two defendants in this particular case, and they basically, and they're juveniles at the time, and they plan the murder of this young lady that you see depicted in the photograph. And when you're done watching that, I want you to go back to this portion on age, and I want you to think in your mind, did they have the adequate mens rea? And if you think that they did, what do you believe their punishment should have been? So something for you to kind of think about. So now let's move on. We got to get through the rest of this. What about entrapment? Well, entrapment is an improper or illegal inducement to crime by enforcement agents. And this defense is built on the assertion, if you will, that if it had not been for government instigation, no crime would have occurred. So again, entrapment defenses may be raised where public law enforcement officials or people acting on their behalf induce or encourage an otherwise law-abiding person to engage in illegal activity. And you're probably thinking to yourself, how can that really happen? How can you induce somebody to be involved in illegal activity? Well, a couple of examples that we can look at, just really brief, would be, what about prostitution? Let's say that we have an issue with prostitution in our town, so we're going to target those people that solicit prostitution. So we take a female undercover officer and we put her out there on the street and we dress her as a prostitute, if you will, and basically people start pulling over and soliciting her. Is that a form of entrapment, or is there a mens rea on the part of those people that want to solicit a woman for prostitution? What about the example, maybe you've watched the show Bait Car, which is actually kind of a cool show, and they place a vehicle in an area where they're having some thefts, some auto thefts, and let's say they leave the keys in the car and they basically walk away from the car. And is it entrapment when some individual walks up, sees that there's keys in this car? It's not their car. They get in it, start it, and drive off. Is that entrapment? Is the government encouraging or inducing someone to commit a crime? So again, a couple of interesting things. So the two most common entrapment activities are false representation by enforcement agents that are calculated to induce the belief that the illegal behavior is not prohibited. And number two, the use of inducements to crime that are so strong that a person of basically average intelligence or what have you, or average will and good intent could not resist. So here's an example. We're having some thefts from vehicles. So we take a car that's owned by the police department and we park it in a neighborhood where we're having some of these thefts. And on the front seat, we leave a brand new Dell laptop computer. Now we roll the window up and we lock the doors. But at some point, somebody comes by, they look in the window, so they smash the window, let's say with a rock or something, and they take the computer? Was that inducement so strong that a person of average will and good intent could not resist? So again, it's an interesting kind of excuse, if you will. And along with that, let me just kind of go into this real quick. Entrapment cannot be effectively raised as a defense, however, where government employees merely afforded opportunities or facilities for the commission of an offense, or where law enforcement officers or their representatives engage in what we call mere fact of deceit. In other words, an undercover sting operation set up by the government to lure burglars and thieves who want to sell stolen property would be legal, whereas government enticements to steal might not be. Does that make sense? So the line between manufacturing crime and simply participating in a crime is kind of a fine line. And there are two tests that have been developed over time to determine when the government has kind of crossed that line. And those are the subjective and objective tests. So the two different tests, or two different legal tests, have been developed to determine when the government has crossed the line, and again, subjective and objective. The subjective test excludes from criminal liability people who are otherwise innocent, who have been lured to the commission of the prohibited act through the government's instigation. The subjective test, however, attempts to distinguish between those who are blameworthy and those who are not, by asking the question, or asking whether a person caught by the government was predisposed to commit the crime in question. In doing so, it distinguishes unwary criminals who are ready and willing to commit the offense when presented with favorable opportunity from those who are not. So hopefully that kind of brings a little, or sheds a little light on that. And I have a little diagram here that shows the difference between subjective and objective entrapment. Again, and we kind of went through this already, but just by definition, the subjective test attempts to distinguish between those who are blameworthy and those who are not, etc. And the objective test, sometimes referred to as the defense of outrageous government conduct. So a couple of different tests for you to kind of look at, but just remember those two tests. Oops. All states recognize the defense of entrapment, and some have actually written laws or codified it, and no state allows entrapment as a defense to serious crimes such as rape or even murder. Now, I have a really cool little video where a local police department in the county of San Bernardino, they have an issue with people that are texting and driving, and basically they disguise themselves in a sting operation as a homeless individual, and this person was watching people pull up to a light, if you will, or pass by on their phones because people weren't paying attention. If the officer stood out there in uniform, people wouldn't do it. But because he was disguised like this, and the sign he even has, which is kind of funny, it says, "I'm not a homeless person, I'm a police officer looking for cell phone violations." So watch that. It's kind of an interesting thing. And I think you'll kind of get a kick out of it. So moving on, let's look at syndrome-based defenses. Now, some defense strategies use certain syndromes to justify their actions. And we're not going to go in detail of all of these. I just want to kind of run down the list. So there are different syndromes: battered wife syndrome, battered child syndrome, rape, trauma syndrome, sexual abuse syndrome, urban survival syndrome, black rage syndrome. There are all different types of syndromes that are out there. Now, in medical literature, a syndrome is defined as a complex of signs and symptoms presenting a clinical picture of a disease or disorder. And if it can be demonstrated that a person charged with a crime was suffering from such a known syndrome at the time of the crime when it was committed, such a showing may lower or eliminate criminal liability in at least 3 different ways. And we'll talk about those ways in just a minute. So, battered women syndrome is a condition said to characterize women who live in abusive relationships. Now, it's not a defense in itself. It may provide additional justification for a woman who kills a battering spouse during an episode of battering when the threat of serious bodily harm or death is imminent. And one problem with all defenses based on syndromes is that there is no syndrome that includes murder or, homicide or any other law-breaking behavior as a symptom of or as an inevitable result of that syndrome. So there are bona fide syndromes, but again, there's not a syndrome where that syndrome includes homicide or specific law breaking, if that kind of makes sense. A couple other quick things on syndrome. Let me get back to the 3 things. So again, we talked about if it can be demonstrated that a person charged with a crime was suffering from a known syndrome at the time of the crime was committed, such a showing may lower or eliminate criminal liability in at least 3 ways. 1, it may help support the applicability of a traditional defense, including justification. 2, it may expand the applicability of traditional offenses, including justifications. Or 3, it may negate the mens rea, that mind thing again, needed to prove the offense, leading the jury trial judge to conclude that a crucial element necessary to prove that crime is missing. And some have suggested a 4th possibility, however, and that is the creation of a new affirmative defense in which novel and unique defenses beyond those recognized by law now would take their place alongside other more traditional defenses like duress, mistake of fact, self-defense, etc. And again, these claims could be termed syndrome-based defenses. So time is kind of getting close, so we need to push on here to the last one real quick. Let's talk about mental incompetency. Competency to stand trial. A finding by a court that the defendant had sufficient presentability to consult with his lawyer with a degree of rational understanding, and that the defendant has a rational as well as factual understanding proceeding against him or her. Now we're talking about mental incapacity. So again, mental competency is an important concept in law, particularly criminal law. A defendant's mental state is assessed using 2 different legal tests at various points in the criminal justice process. And the two most significant points are at trial and at time of the commission of the crime. And so first, I kind of gave you the definition of, mental incapacity or incompetency. So let's talk about that one first. So due process requirements prohibit the government from prosecuting a defendant who is legally incompetent to stand trial. And competency to stand trial may become an issue when a defendant appears to be incapable of understanding the proceedings against him or her, or is unable to assist in his or her own defense due to mental disease or defect. Now, conversely, a person is competent to stand trial if he or she, at the time of trial, has sufficient presentability to consult with his or her lawyer with a reasonable degree of understanding and a rationale, as well as factual understanding of the proceedings against him or her. Now, competency to stand trial focuses on the defendant's condition at the time of trial rather than at the time of the crime. And the U.S. Supreme Court has held fundamental principles of due process require that a criminal defendant who is legally incompetent shall not be subject to trial. And in a case, Pate versus Robinson in 1966, the court held that a failure to observe procedures adequate to protect a defendant's right not to be tried or convicted while incompetent to stand trial deprives the defendant of a fair trial. Well, what about that insanity thing? Insanity at the time of the crime. Well, although the question of competency to stand trial may be vitally important to defendants who claim insanity at the time of trial, another important issue revolves around the need to determine whether a criminal defendant was insane at the time the crime was committed. Does that make sense? It is that question with which we will be concerned throughout the remainder of this discussion, this insanity thing. And the insanity defense, like other defenses that have been found in place in our legal system, exists because, as the famed jurist David Balazon once observed, the criminal law is an embodiment of society's moral vision. Therefore, he says, finding a defendant guilty is not only a factual judgment, it also constitutes the moral condemnation of a person. In our tradition, moral blame cannot attach where an act was not the result of free choice. The verdict of guilty by reason of insanity is nothing more than an expression of that moral institution. And furthermore, other punishment objectives are not satisfied when the offender is in fact insane. So, insanity can influence criminal liability in two ways. One, it may result in a finding that the mens rea required for a specific crime was lacking, leading the court to conclude that no crime occurred. Or it may lead to a showing that although the requisite mens rea was present at the time of the crime, the defendant should be excused from the legal responsibility because of mental disease or defect. Now, talking about a common misunderstanding, the ability to distinguish between moral good and evil is quite a different issue than that of demonstrating a culpable mens rea. When mens rea is understood as purposeful or intentional behavior. And those who are suffering from mental illness may still act purposefully, even though they may not, due to mental disease, be able to fully appreciate the moral implications of their behavior. And two real quick cases. One on top is Andrea Yates, and this is the woman that drowned her 5 children. And the picture at the bottom was a woman who drove her children into the ocean in an attempt to drown them. So again, just this is, we're talking about the insanity defense. So what is insanity? Let's define it at least really quickly here. While the law has its own definition of insanity, which is sometimes at odds with the psychiatric definition of mental illness, it looks at it like this. A person may be mentally ill or mentally abnormal and yet be legally sane, and vice versa. The term insanity is a legal term and not a psychiatric one. So, and if you were to look it up in the dictionary, the authoritative Black's Law Dictionary warns the term insanity is a social and legal term rather than a medical one. Okay, it goes on to define the concept as a condition which renders the affected person unfit to enjoy liberty of action because of unreliability of his or her behavior, with concomitant danger to himself and others. And it continues by saying that the term is used to denote that degree of mental illness which negates the individual's legal responsibility or capacity. In other words, the law has its own definition of insanity, which is sometimes, again, at odds with the psychiatric definition of mental illness. And there are some tests that have been brought about in order to deal with this issue of insanity. And insanity got its defense, just quickly. It has its modern roots in a 1843 case of Daniel Macnaghten, a woodcutter from Glasgow, Scotland. Macnaghten appears to have suffered from what today might be called paranoia or delusions. And he believed that he was in some way being persecuted by Robert Peel, who was the then Prime Minister of England. Now, Macnaghten traveled to London with the intention of assassinating Peel and would have succeeded but for the fact that Peel chose to ride in the carriage of Queen Victoria and not take part in the event, actually. And Peel's carriage was occupied by another person, Edward Drummond, Peel's secretary. And it was Drummond who Macnaghten killed, believing him to be Peel. Now, upon his arrest, Macnaghten told the police that he had come to London to kill the Prime Minister because everything in his power was drawn and he was being persecuted, and he was having these delusions, if you will. Now, the Macnaghten case was formalized, or the Macnaghten case formalized a couple of different tests and brought them together in order to come up with this basic understanding of right and wrong. So the Macnaghten rule is basically knowing right and wrong, and this is a rule for determining insanity that asks whether the defendant knew what he or she was doing, or whether the defendant knew what he or she was doing was either right or wrong. Now, disagreements exist over whether the word wrong refers to the defendant's ability to appreciate the legal or moral wrongfulness of their act. And during the 1920s, there was the irresistible impulse test. So during the 20s, in the belief that some forms of behavior could not be controlled, many states modified this McNaughton rule to permit the irresistible impulse defenses as well. And this was a test for insanity that evaluates the defense claims that at the time of the crime, the crime was committed, a mental disease or disorder prevented the defendant from controlling his or her behavior in keeping with the requirements of law. And then finally, there was something also known as the Durham Rule. And it was also talked about as the Product Rule. And it was built on the court's belief that an inability to distinguish right from wrong is merely a symptom of mental disease, and that behavior resulting from the disease is more apt determinant, or is a more apt determinant of legal insanity. And again, this rule too has many critics, and some claim that it is extremely far too vague. Now, the American Law Institute incorporated a substantial capacity test into the Model Penal Code, which is a modernized version of the McNaughton rule, blended with control rules. So it substitutes the word appreciate for know in the original McNaughton formulation and recognizes the role of impulse through the use of the phrase conform his conduct to the requirements of law. And the Insanity Defense Reform Act made insanity an affirmative defense to be proven by the defendant by clear and convincing evidence, and created a special verdict of not guilty by reason of insanity. And Congress intended to prohibit the presentation of evidence of mental disease or defect short of insanity to excuse conduct. Guilty by mentally ill, a verdict equivalent to a finding of guilty that establishes that the defendant through mentally illness or mental illness was sufficiently in possession of his faculties to be morally blameworthiness for his acts. And then finally, the doctrine of settled insanity. The habitual and long-term use of intoxicants or other drugs that results in permanent mental disorders that are, quote, symptomatically and organically similar to mental disorders caused by brain disease, can create a basis for the claim of insanity, provided that the defendant can meet the required definition of insanity in their relevant jurisdiction. And then the phrase diminished capacity, to finish up, is a defense based on claims of a mental condition that may be insufficient to exonerate a defendant of guilt, but may be relevant to specific mental elements of certain crimes or degrees of crimes, also called diminished responsibility. Now, the Model Penal Code limits applicability of diminished capacity to cases in which capital punishment might be imposed. And then civil commitment. Today, many states and the federal government have directly connected criminal cases and civil confinement, particularly for sex predators. These laws typically provide for the civil commitment of dangerous offenders with periodic reviews for dangerousness and mental illness following their prison sentences. Okay, and that was a lot. So we went over our time a little bit. I apologize for that, but I wanted to try to squeeze everything in. I hope you understood some of the excuses as we went through this chapter. Now, just to kind of sum everything up, don't forget to look at the summary at the end of the chapter, and also please take the time to review the definitions as well. With that being said, that will be the end of the Chapter 6 lecture, and until next time.